Hello and welcome to today's episode of Legal Talkies with Abhijit. I am your host, Advocate Abhijit Negi, and today I wish to discuss on the topic of mediation in context of the Mediation Association of India, which was recently formed on the 3rd of May. And it is interesting and useful to note that on this day, the first mediation conference was held, which was graced by the President of India, and there were other dignitaries from the Supreme Court as well as the Bar Council of India and other members of the bar and lawyers and other stakeholders who participated in this conference. So I would like to today through this episode focus on the impetus which is being given to mediation through the formation of this Mediation Association of India, which was formed on the 3rd of May, which also was declared as the National Mediation Day going forward. So I wish to speak about certain aspects and highlight certain aspects of this conference, first mediation conference. And with respect to that, I would like to speak regarding the President's address briefly first, and then go on to Justice Nagarathna's speech, through which she has pointed out certain pointers or rather suggestions which, if incorporated, could lead to better realization of justice through mediation as a form of ADR or alternate dispute resolution. So let me begin by speaking about what the President said. The President mentioned how mediation is an essential part of the justice delivery system, which is at the heart of the Constitution of India, and that there is an urgent need to reduce the ever growing burden on the courts due to burgeoning or overgrowth of uh, legal cases as are pending before the judiciary in India, the courts. And she mentioned about a very legendary example of the panchayati system of justice, which has been prevalent in India, and mentioned how today the institutional loophole which exists is being sought to be plugged after the legal reforms, which includes, most importantly, the passing of the Mediation Act, the standalone legislation. Mediation Act was passed in 2023. So now there is a greater push and sanctity to the mediations which happen without the intervention of the courts. I would be remiss not to point out the example of Gandhian form of dispute resolution that she pointed out as to how Gandhiji, as a young barrister, as a young lawyer, ensured during his days of practice, when one of the matters was referred to him, that it was amicably settled through the process of mediation rather than through the long and arduous as well as time consuming plus uh, monetarily more expensive form of traditional form of dispute resolution. So he chose this to foster a spirit of harmony over discord, which is what is at the core of the Mediation Act, as uh, said, as shared by the President of India, the Honorable President. Now, moving on, very interestingly, Justice Nagarathna's speech uh, touched upon various facets. I would briefly speak about them, and I would like to start by speaking about one question which is in the minds of a lot of us when we speak of mediation. So, what are the benefits or what are the advantages of mediation over the traditional forms of dispute resolution, which is through the judiciary or court legal system? So, she mentioned that firstly, when a matter is settled by a mediation, it need not necessarily go to courts as opposed to other ATR forms. In this context, it is important to note that a mediated settlement under the Mediation Act 2023 actually has the force of a decree as per the Civil Procedure Code. She mentioned then about the pre litigation mediation and how it is useful in certain forms of dispute concerning family relationships, commerce, and contracts, and disputes with neighbors, and family disputes, and so on and so forth. And how these matters can actually be prevented from going to court by opting for the option of pre litigation mediation. She also mentioned how pre-litigation mediation has been incorporated already in a few legislations as of today, such as the Commercial Courts Act, Section 12A, as also the uh, Permanent Lok Adalat through the Permanent Lok Adalats. And then she interestingly spoke about another important facet which I intend to speak about briefly about the Mediation Act 2023 and how there are certain forms of mediation which this Act of 2023 recognizes. She spoke about three forms which I would like to speak about as well. She spoke about the institutional form of mediation through the mediation service providers. Then she spoke about the online form of mediation or the e-mediation, and then she addressed the community mediation. There is also a hybrid form of mediation which is increasingly being opted, though not perhaps as readily as we would like, as promoters of mediation and uh, as much as we would like, it is not being popularized so much as of now, but it has started happening. So, what happens in hybrid mediation? Hybrid mediation could be in a form where it is a dispute resolution clause, when mediation is rather opted as a dispute resolution clause, which is mixed with other forms of ADR or alternate dispute resolution, such as, for example, arbitration. So, an arbitration could commence and it could be stated that, let us say, before the arbitration commences, mediation has to be resorted to. And once mediation fails, then arbitration can be continued. Or, on the other hand, it could be arbitration mediation clause, which says that arbitration is to be carried out, and in case arbitration is not fruitful or at any point it can be paused, and mediation could be resorted to through a panel of mediators. This could happen, for instance, after the issues are framed. The matter can be referred to the arbitral tribunal, by the arbitral tribunal rather, to the panel of mediators, and that portion of settlement can be recorded in the final decision or judgment by the arbitral tribunal, which records through the process of mediation the settlement of the dispute in question. Then, and another interesting suggestion which was brought up by Justice Nagarathna was with respect to the impanelment of mediators and arbitration centers associated with courts. For instance, in the Delhi High Court, we have the DAIC. In that arbitration center, we could have a panel of mediators to ensure that the hybrid forms get the due attention, and rather some of the disputes which come in through uh, arbitration, which is by itself a form of ADR, can then be resolved through resorting to mediation as well. And at the same time, mediation as a form of ADR or alternate dispute resolution can be further popularized. Now, another important facet that was covered in her speech was with respect to the government contracts. That there could be now mediation clauses and arbitration agreements which are there frequently in the government contracts, as now government is increasingly opting for, or rather more wary of, the arbitration clauses, which are again found to be time consuming as well as resource intensive in terms of the expenses. So, to avoid litigation disputes going to court, there could be med-arb or arb-med clauses, that is, hybrid clauses in government contracts as well. Other notable suggestions which were made were with respect to awareness programs for promoting the scope and benefits of mediation, highlighting the importance of mediation through the uh, DLSAs or the state legal services clinics or centers, through targeted workshops. Another very important suggestion that was brought up in our speech was with respect to having ADR, or rather mediation, as a standalone course instead of it being part of the ADR or alternate dispute resolution course in general in law schools. Then, another interesting aspect was with respect to infrastructure obligations. Now, often it is seen that language is a barrier. So, in this respect, it has been suggested that there can be multilingual resource materials apart from English to explain the benefits of advantages of mediation, and there can be a greater dissemination of the same through court notices as well if the multilingual approach is adopted. and regional languages are also used in the dissemination and popularization of mediation. Then the issue that was addressed or rather spoken about was also with respect to the e-mediation or online mediation. So now there needs to be a special education and training in using digital or e-mediation to mediate disputes. That is, the mediators need to be made aware of the various digital tools, and the digital infrastructure needs to be developed. And then, of course, there needs to be special training for the mediators also, so that they are able to adopt online mediation. In this respect, I just wish to share an experience that I myself as a lawyer faced. So, in a matrimonial dispute, my matter in the High Court was referred to mediation, and I found out that the court appointed mediator was very reticent or hesitant rather to to actually use ODR, or rather the online form of mediation, to mediate. And she was indirectly, or in so many words, insisting that the parties must be physically present on every date of mediation for mediation to progress further. So this actually shows that there is, at the grassroots level or at a very basic level, a hesitancy to use e-mediation or online mediation due to lack of knowledge about the digital infrastructure associated with it and how to conduct an effective mediation through online mode. Moving on, there is also a urgent need to set up a national mediation helpline also at the state level and the district level, and popularize them so that more information can be disseminated regarding the process of mediation, and there can be greater awareness among the general public regarding the same. Tied to this is another very important suggestion of system of feedback or suggestion box to invite suggestions, either from an online perspective or an online forum, or through a local mediation center where suggestion boxes can be placed. Then we come to the process of identifying good mediators. How a formal schedule for mediators to attend to the mediation centers needs to be made at all levels, including the district level, and the empanelment of mediators needs to happen on a greater scale at all levels, as well as the suggestion of a 40-hour compulsory course, not just for the mediators, but also for the judicial officers, to enable them to identify certain disputes which can be referred to mediation effectively. And there is also the another very important suggestion of an ongoing or a continuous training program that needs to happen for the mediators on an ongoing, on a rolling basis, as opposed to just the initial training, so that the mediators are themselves uh, aware of what is happening and the latest trends in mediation as well. Then another very important suggestion which I think can make a difference is with respect to mediated settlements, where it has been recommended that 75% or even perhaps 100% of the court fees may be refunded to the plaintiff, to the parties who instituted the litigation in the first place, who paid the court fees, so as to incentivize them to opt for mediation as a form of alternate dispute resolution for resolving their disputes. Now, another important facet that I need to discuss or bring your attention to is the kind of references by judges which is brought about by Justice Nagarathna very rightly, where she mentioned how the voluntary references by judges for mediation are not very high, or the rate of voluntary references are dismal. While some cases are referred, some are not able to be identified, and there is a problem with respect to how to identify certain disputes which are fit for reference to mediation. And in that respect, there is an urgent requirement for training of judicial officers by mediators, as suggested by Justice Nagarathna. So she also spoke about, in general, about certain other incentives for mediation for corporates and private companies, which may be given by the government, and the need for including mediation clauses in all private party contracts as well as government contracts. There was also a very important reference to the Mediation Association of India, as an interface for promoting dialogue on mediation at all levels, which is the central, state, and district level, and ideas and suggestions to be given to the Mediation Association of India, which has been recently, which has recently come into being as of the 3rd of May 2025. 2025. Now, again, another suggestion was with respect to the National Judicial Academy and the State Judicial Academy to have refresher courses and seminars for promoting mediation among the various stakeholders, including the lawyers and the judicial officers. And uh, it was also rightly mentioned how 3rd May is being celebrated and has been declared to be celebrated as the National Mediation Day. And on the similar lines, there could perhaps be a National Mediation Week to settle disputes by mediation, as we have a mega Lok Adalat week to clear out the cases through permanent Lok Adalats as well. Which brings me to a very important and focal point, which was mentioned in the speech of Justice Nagarathna. She spoke about the fact that all the persons in favor, or all the stakeholders who are in favor of mediation, including the lawyers and the judges, had congregated in the first national mediation conference, which was held in May 2025. But she pointed out how those opposing views of those not in favor of mediation are not being taken into account as a potential roadblock, which may lead to lesser dissemination and popularization or lesser acceptance of mediation as a tool for dispute resolution. She mentioned how there's a negative perception among certain lawyers about mediation as eating or taking away from their law practice and reducing their income. In this respect, she mentioned how it is very urgent and important to change the perspective of lawyers uh, and ensure that the lofty ideal of justice and fairness and justice delivery system is maintained by using of mediation as a tool of dispute resolution. And towards the end, there was also a mention about how wakalat is not required in mediation and how lawyers can be encouraged to appear through memo of appearance before mediators for settlement of disputes. And the Honorable Judge also called upon the Attorney General as leader of the bar to convince lawyers regarding opting and using mediation as a form of alternate dispute resolution for the settlement of disputes. I hope you found this episode useful, and I look forward to hearing from you about your views regarding the same. And I'm open to any suggestions that you may have regarding the same. Thank you for your time.